Good morning, everyone. Today is Thursday, April 2nd. It is approximately 10 a.m. Pacific Standard Time. This is our daily podcast where we provide you with updates and talk about legal topics. Today's topic is going to be specifically on the issue of domestic violence and domestic violence restraining orders. Once again, I'm joined by the Family Law Legal Panel. I'll give them each an opportunity to introduce themselves. As you're joining the meeting, please make sure that you are muted. If you have any questions, please feel free to send them to me. Other than that, the recording will be posted on our social media websites, YouTube, and Facebook. And then we will also send it to anyone who's requesting a copy of it. So let me start with the introductions. Gina, tell us about yourself.
Sure. My name is Gina Famularo. I am a partner at Family Law Matters. I've been an attorney for 23 years this May, and I have practiced for 13 years in Riverside County, the balance of my career in Orange County.
Thank you, Gina. Christy.
Good morning, everyone. My name is Christy Bergamo. I'm a senior family law attorney here at Family Law Matters. I've been practicing 17 years, and I have experience as being minors counsel in the superior courts, which means I'm appointed by judicial officers to assist children in their matters. And I have sat Judge Pro Tem in Orange County for the last 3 years. So good morning.
Thank you, Christy. And Colleen.
Good morning, everybody. My name is Colleen Robinson. I'm an attorney here at Family Law Matters. I've been an attorney for 10 years, practicing in San Diego County, Riverside County, and making appearances all over Southern California. And my practice has almost exclusively been in family law.
Thank you, Colleen. I am Kishore Shahada. I am managing partner here at Family Law Matters. Been an attorney for a little over 2 years. And that's it. So let's get started. Gina, tell us, what is domestic violence?
Sure. Domestic violence is any unwanted contact, I guess is the best way to put it. It is where one party exerts power or control over the other. Usually you can tell if you're a victim of domestic violence because you are doing things out of force or fear. So that could be broken down into stalking, harassing. It could be physical harm. It could be threats of violence. Anything that makes someone feel unsafe is typically in the domestic violence umbrella.
And I know you just went into 4 separate categories. So can we dissect those a little bit more? Can you tell us what constitutes stalking?
Sure. Stalking would be things like showing up at one's house uninvited, showing up at one's house after they've been told not to show up anymore, showing up at one's place of business, again, uninvited or after they've specifically been told not to show up. It would be calling someone excessively. And when I say excessively, I'm not talking 1 or 2 times a day. Typically, it's dozens of times a day. It's unwanted email contact, unwanted text messages. It could be reaching out to somebody on their social media like Facebook. It's frequently getting a new number when your number's been blocked. So for instance, calling, the person blocks the person's number. They then either generate a random number or use someone else's phone. It would be monitoring the movements of somebody, and it would be, again, excessive. It could be driving by their house several times a day, those looking through their window.
Thank you, Gina. And Christy, I know you've had some recent run-in with the second category, which is harassing. So tell us a little bit about that.
Yes, and I think that segues into what Gina was talking about in terms of, I think we always start with unwanted contact. And I think that stalking and harassment somewhat overlap each other, which means that it does include numerous phone calls, getting in, one's face, not allowing them to live peacefully, I guess is the best way to describe it. But it's got to be more than just, repetitive. I think it's got to be out of the ordinary in terms of the unwanted contact. And I think the threshold issue here, and I don't want it to be left aside, is that it's unwanted. So therefore, what you need to do as if you are a victim of domestic violence is lay that line in the sand. Do not contact me anymore. Do not email me anymore. Do not, call me anymore. Don't go on my Facebook, whatever it is. You have to set that boundary, and you can't open up that boundary again. I think you have to lay that boundary, so then that is good evidence to the court when the court reviews that you said don't contact me, and that contact continues. We all have a right to live in peace, and when that is breached, that's where you get into issues of harassment.
And Christy, what about calling someone at their workplace?
Well, again, I mean, you look to the standard of what your contact with this person was. And once that relationship is over, then contacting someone at their work is absolutely unwanted contact. I've had cases where the perpetrator has contacted their employer and contacted, their coworkers, disseminating information if it's private or even if it's true, but in a mass email to somebody, email to people about you, that is all constitutes harassment. And
I think you hinted towards it, but I want to be more specific because these are questions that we're getting. Posting naked pictures of someone.
Right. And social media has really taken this to another level. And I see it all the time in my practice where someone's own, so it's the perpetrator's page. And what they do on their page is that they post things about the victim. And, I've seen cases where if even though there is a First Amendment right, if you do that on a very massive level, it may be construed as domestic violence.
Thank you, Christy. And Colleen, I want you to tackle the third category, which is threatening. Mm-hmm. Tell us what constitutes threatening.
Threatening is imminent or fear of imminent bodily injury, or even sometimes it could be emotional as well. So it does not require physical touch to be considered domestic violence. You have to have a reasonable apprehension that something's going to happen to you. And I've seen this, and particularly when it's in conjunction with these other categories, that this becomes a very good case for domestic violence for a temporary restraining order, not only to be granted, but when we'll be talking more about this too at the permanent restraining order hearing, this is also something that the court is inclined to grant on a permanent basis.
What about, I'm sorry, are you guys hearing an echo on my end?
A little bit.
Okay, is it better now?
I think so. We'll see.
What about threats like, I'm going to get you, I'm going to kill you, you better not do that or you'll be sorry, or I'm going to hit you, just these words, is that sufficient?
Yes, those are, if you have reasonable apprehension that you are going to be injured in that way or abused in that way, then absolutely, that does count, and it falls under this umbrella of domestic violence. And I've seen those types of instances get granted for a temporary restraining order and even get at the permanent restraining order level as well. Even threats or comments that I'm going to kill myself and take you down with me, things like that, that also constitutes domestic violence. I mean, you are in fear of that type of behavior, so that does count as domestic violence.
And a couple of more examples to get the point across. What about punching a wall or throwing something past the person? It never hit the person, or it never, it went past them or fell, at their feet, or brandishing a knife, pointing a gun at the other person. Are these threatening?
Absolutely. I mean, to be in that room and those behaviors are occurring around you, well, first we got to take it down. If you're in the room there, that's going to be a very strong case of domestic violence. If the further away that it gets from you, we have to take a look at that as well. But punching holes in the wall, damaging property, and that's very aggressive behavior. Brandishing a weapon, even if it's not what's a traditional weapon, whether that's a gun or a knife. It could be a rolling pin. It could be a piece of furniture. Or a cell phone, throwing cell phones at one another. That is also considered domestic violence. Plates. I mean, we've seen it all in terms of what people have used in terms of weapons for domestic violence, and that is considered domestic violence. In the courts take that just equally as seriously as being physically harmed in most cases. That's frightening, especially if you have children in the room too, which is something else we're going to be talking about, and they're witnessing this type of behavior. That's very concerning. If the threshold is that behavior, that aggressive behavior that you have witnessed, if that is causing you to have apprehension of being abused in that regard, then absolutely that counts as domestic violence, or it can count as domestic violence.
Now, I'm gonna bring you in on this because one of the comments that was just sent to us was, what about pets? And I think that fits into the fourth category of harming.
Mm-hmm.
And what happens if, I mean, he kicks the dog, or she or the perpetrator kicks the dog? What is that? Does that constitute domestic violence?
Well, it's really interesting how pets are becoming more and more involved in family law. Before, not many years ago, the courts drew a hard line that pets are considered chattel because they didn't want to get involved with making those kind of orders regarding animals. But now that is all changed. So I think that, again, looking at the totality of the circumstances, which is a very loaded legal word, if harming animals, threatening to harm you, witnessing aggressive behavior, all of that is taken into consideration and can fall under this panoply of domestic violence. So any violent behavior needs to be addressed with the court when you're pleading for relief under the Domestic Violence Prevention Act.
Thank you, Colleen. Gina, the question's for you. What's the time frame? For example, I'm in a relationship. There was an incident that happened a couple of years ago where there was actual physical harm, but nothing, with nothing that satisfies any of the four categories that you guys have put forth today. What's a good time frame to be looking at to consider for restraining orders, Gina?
Are we talking about how long ago the acts need to occur?
Yes.
So domestic violence can include anything that happened in the last 5 years. Typically, though, you're going to need an apprehension of harm, as Colleen indicated. It could be emotional, it could be physical, it could be disturbing the peace of. So typically what we would do as attorneys is we would look 5 years back to see if there's been any sort of history of domestic violence. And then we would look at why the person is fearful now. Most domestic violence is not physical. 90% of it or more is one of the categories we've already talked about: harassing, stalking, or causing the apprehension of. In my practice, what I've noticed is usually the physical violence is in the distant future. Why? Because it only takes one time to have your nose broken, and pretty soon you're going to do what the person says without having to be punched in the face again. So in my experience, a lot of times the actual physical harm happens early in the relationship, and if the victim stays, the abuse becomes more subtle. It becomes brandishing a cell phone, which in the victim's mind means it may be thrown at them. Holding a bat, which in the victim's mind could be that the person's going to be hit with it. But we go back 5 years, and then what we do is we look for something more recent. And depending on how severe the harm was in the past, will depend on how subtle it needs to be in the future to still be defined as fear of harm.
And when you're talking about, just to go back to the fourth category real briefly, when you're talking about actual physical harm, you're talking about punching, choking, twisting someone's arm. Is that the type of physical harm you're referring to?
Sure. So the type of harm that Colleen was referring to was punching something like a wall or a door. Very common. Sometimes, though, it escalates, and it includes spitting at somebody, pulling someone's hair, choking them, grabbing their arms, even if it is not necessarily to the point where the person feels bruises. It could be, I don't know that we talked about blocking someone's egress, preventing them from leaving a room. It could be that they're standing in the door physically, not allowing the person to go by. It could be that they chest bump the person. It could be that they hold them down. Other examples would be, an extreme example I had was somebody getting hit in the head with a fireplace poker on Christmas Eve in front of their 3-year-old child. Those are incredibly unusual. That happened to me, for instance, 10 years ago, and I still remember it because usually that's not the case. Domestic violence is usually much more subtle. Again, usually how you can tell if you're a victim of domestic violence is you're feeling fear or anxiety to the point where you're doing something that you don't want to do. The other person is controlling you just through subtle behaviors.
And Gina, what about, where does financial control and dependability fall into these categories?
Sure. Financial control is more of a signal. It's more of a way that you can tell whether or not you're a victim of domestic violence. It's very common for the perpetrator to want complete control of the victim. That would include isolating the person from friends or family, denigrating one's friends and family, denigrating one's stepchildren. That's another common one. Pushing adult stepchildren away, cutting off the checkbook, not providing any credit cards to the person, making the person feel like you don't work, therefore it's my money, you don't get any. So it's one of the warning signals. One of the things that we look for as attorneys to determine whether or not domestic violence exists in this relationship.
So if I understand you correctly, those by themselves don't constitute domestic violence, but they're signals that we need to be looking for when we're trying to determine whether there is domestic violence or not. Is that true?
I guess it would be a gradation of domestic violence. I think it would be considered domestic violence, but would that in and of itself be so severe that you would be able to get a restraining order? I think the answer is probably no. But it's certainly usually coupled, almost always coupled with other activities. And it's a warning signal for us as attorneys to look for.
Thank you, Gina. Christy, I want to bring you back in. So who qualifies to file for a domestic violence restraining order? What type of relationship does have to exist?
Well, it has to be an intimate one. That's the only way I can describe it. It has to be, a boyfriend, a girlfriend, a husband, a wife. It's got to be that type of relationship. I mean, your neighbor is not going to qualify in that regard, but there are avenues that you can seek, which is a civil harassment order if things are going on like that with your neighbor. But it's got to be an intimate relationship between the perpetrator and the victim.
So is the key then intimate? What about parties that are, I'm thinking about today's generation, parties that are living together, but there's no quote unquote title. So it's an open relationship. Is again, to your point, is it intimate? Is the key word intimate?
Yes. And I think the distinction is you can be living together if you're in that sort of relationship and you think about the definitions of domestic violence and what it entails. And obviously, stalking, harassing, threatening, Gina talked about, those types of issues. So obviously that type of relationship requires intimacy in some way, shape, or form. A roommate is not going to count. Yes, you're in an intimate relationship, but a roommate's not going to count. It's got to have that level of intimacy in order to be qualify in the domestic violence setting.
Then if you're talking about the issue of, if your key identifier is intimacy, what about a sister brother or a father daughter, mother son? What about those relationships?
Absolutely, that does qualify. It's that level of relationship that would you would think would require the unwanted contact and the disturbing the peace. Again, those relationships would qualify.
So we're not looking at the word intimate in the actual literal sense of intimate. We're talking about some sort of blood relationship or some sort of maybe sexual relationship, things of the sort.
Correct.
Okay. So those are the ones who qualify. So what happens now if I feel I'm in danger? How do I go about getting a restraining order?
Well, that's a loaded question. There's first and foremost, what we always tell our clients is don't wait for your lawyer's office to open. You need to contact the police. You need to receive their assistance immediately if you are in this situation and it has escalated. Now, if you're on the off part of it, then obviously you'd want to contact us, find out what your legal remedies are in terms of filing the restraining order. But if the violence is going on as you're sitting there, then you need to call 911. You need to contact the police. Now, what the police will do, obviously, if they find that it rises to the level of domestic violence, usually what they do is issue the victim an emergency protective order. And that's of a criminal nature. Normally, the perpetrator will be arrested. They'll be in jail for the moment, and then they will issue an emergency protective order. Now, that emergency protective order only lasts for a very finite period of time. It's 5 days or 7 calendar days. And what that emergency protective order is designed to do is give the victim enough time to go file a restraining order. And that would be in the family courts. And that's the CLETS, the order that we're talking about. So you would draft the paperwork and ask for your relief in the family court, and they will either issue or not issue you a temporary restraining order. And then they will give you a court date 21 days later to have a hearing on whether or not you should be granted a permanent restraining order.
So Christy, if I understand you correctly, when the incident occurs, the first thing to do obviously is call 911 and get immediate protection. The second thing you should do is contact your attorney, because if an EPO is issued and one party is arrested, there is going to be a criminal case for the arrest and the domestic violence that took place. But what you need at the time also is the civil restraining order. Is that true?
That's absolutely correct, B, because like I said, the EPO or emergency protective order in the criminal case only lasts 5 days or 7 calendar days, depending on when you get it. So it's a week really. And so you need, because usually what happens is the perpetrator, bails out of jail. And if that happens, you're only going to have the protection for this limited period of time. So absolutely, you need to file your request for a temporary restraining order. And what you can ask for in the temporary restraining order, not only no contact, but you can ask for, and I know our question was about pets, you can ask for protection of the pets or, exclusive, ownership of the pets. You can ask for a move out order, which is very vital in these types of situations, because clearly you don't want this perpetrator coming back to the home after something like this has occurred. So you can ask for a move out order so they don't get to return to the home once they are released from custody.
Thank you, Christy. Colleen, I have another question for you on that topic. So let's say there was an instance of domestic violence, the police are called, but no arrests are made. Mm-hmm. Can the party still file, and can they still get a restraining order?
Oh, yes, absolutely. And that is not uncommon. That just because the police come out and there's no arrest made does not mean that you're not going to get a temporary restraining order. So, and even just to kind of piggyback with what Christy was saying, you should, if you get an under the circumstances where you're given an EPO, you should absolutely contact your attorney and file a family law civil TRO, because you don't want to also rely upon the prosecutors, the DA's office, the criminal courts to then act on your behalf, and whether or not they even do anything on their end, because they have to go through their own investigation and whether or not it rises to the level on their end to file a complaint and start a criminal case. You should not just bank on the fact that they'll do that for you. You have the power to take it into control on your own end and file your family law restraining order, temporary restraining order. And like as Christy was saying, you have a whole variety of things you could request to protect you as well. Can you repeat your question again? I'm sorry.
That's okay. I think you answered it, and the question is, even if no arrests were made, you can still get a restraining order. My follow-up to you is, what if the incident happened a week or two ago? Can the victim still get a restraining order even though the incident is 2 weeks old?
Yes, yeah, absolutely. As Gina was saying, I mean, we're looking back 5 years, and a lot of times, even when you go to the mentality of a victim of domestic violence, sometimes they're not going to be acting right away because they're in such fear of the abuse that they've been undergoing for such a long period of time. So no, I mean, yes, you can go ahead and file your restraining order even if it happened 2 weeks ago. And then we'll explain to the court at your hearing, you know, if it even comes up as to why you waited 2 weeks. And that's just something that we can easily explain.
And what about if the police are called and they say, you know what he's doing is okay, it's perfectly legal, it's his house, he can do it?
Mm-hmm.
How does that affect the victim's ability to get a restraining order?
It doesn't, because it's not the police officer who's granting a temporary restraining order. It's a family law judge. And the family law, the police officer that arrives to the scenario or to the scene in the example that you're providing, he or she may not know the whole history. He or she may not know that there's been years of this going on, that this is just one snapshot of like 50 that have been going on, where a family law judge is going to sit and look at all of these instances that are described and then make that decision as to whether or not a temporary restraining order should be issued in this particular case.
Thank you, Colleen. Gina, I want to get into the specifics now. I want to get into the details. So what happens when we file for a restraining order? I know that there's talk about a temporary versus a permanent. So walk us through the process. A victim of domestic violence hires an attorney. We file for a restraining order. What happens then?
Well, first off, we file for what's called a temporary restraining order. That is granted over the counter, meaning that we take it to the clerk's office. The clerk walks it back to the judge. The judge reads the facts of the case that we've set forth and then determines whether or not there is enough to issue emergency orders. That would be based upon stalking, harassing, threatening, or harming, as we discussed already. The orders will then either be granted or denied, and a permanent restraining order will be set 3 weeks out. At the hearing on the permanent restraining order, the court will then hold a trial, and the victim will have to testify. The perpetrator or the accused can bring witnesses and can defend themselves, and then the court will issue a ruling.
Thank you, Gina. And I guess so it starts with the filing, then there is a hearing in 3 days. So for example, if we file for a restraining order and the temporary is not granted, is there still a hearing?
Absolutely. Number one, there's still a hearing. And number two, there can still be permanent restraining orders issued, even if the temporary restraining orders are not granted. And I'll go one step further for you. I've seen cases where my client has been arrested. The other party goes in and gets a restraining order. My client is the victim. We then file a request for a restraining order. Not only is the person who's arrested not prosecuted, but the supposed victim, the actual perpetrator who got our client arrested, their restraining orders denied and our restraining orders granted. So whatever happens at the temporary, that's just a very cursory look at the facts. Like Colleen said, we're not going into the whole history at that point. We're just looking on the surface. When we go to trial, we have the ability to look at everything. We can go back those 5 years we discussed. We can talk about all the acts of harassment and threatening and stalking and hurting that have happened over the past 5 years. It all gets to come in, and it's the totality of the situation which will determine whether or not a restraining order is granted.
Thank you, Gina. And then the final question I have for all of you, and I'm going to give each of you a chance to elaborate on it, is what are the ramifications for both parties of a restraining order in a family law case? Gina, I'm going to start with you since you're here.
Well, there are wide-reaching ramifications if you are being accused of domestic violence. Over the 22 years or 23 years that I've been an attorney, I don't know how many times I've sat in court and seen somebody who's unrepresented. The judge calls the case and asks the unrepresented party, sir or ma'am, you're being accused of domestic violence. They're asking for a restraining order. Do you object? And they say something along the lines of, my girlfriend and I have broken up. I never want to see her again. I have no problem if the court never seeing her again. I don't care if I get a restraining order. It's one thing not to have contact with somebody, but what people don't understand is, what does that mean? That boyfriend, that ex-boyfriend who's sitting in court that just agreed to a restraining order now can't carry a gun if they have them. I've had cases where federal agents have gone to people's houses and knocked down their doors because they have guns and a restraining order. They can't get certain jobs. You cannot pass a background check at Walmart because now you have a restraining order. Perhaps you're in the military and now you can't be promoted because you can't pass a security clearance. You can't be an ambulance driver. You can't be a teacher. You can't be a doctor or a nurse. If you are, you have a green card, you could be deported. There are wide-ranging effects of this. Perhaps you're going to lose custody of another child because you now have a restraining order, and there is a presumption that any children that you have should not be in your care because you have a restraining order against you. So it is draconian.
Thank you, Gina. And Christy, Gina highlighted the ramifications for the perpetrator of domestic violence. What are some of the ramifications for the victim of getting a restraining order?
B, I'm so glad you just asked me that. As Gina was talking, I was writing my notes down, and I started thinking of Gina's making such a good point about the ramifications to the perpetrator, but I'm going to take the opposite side, which is why I'm glad you asked me this question. I've sat in court where victims of domestic violence file these domestic violence restraining orders in pro per and choose to represent themselves in these matters. And this is, they're wanting protection of their lives. And I have seen it time and time again that they don't know how to present the evidence to the judge effectively. And I'm sitting there and I'm watching this pro per, and I know to the core of me that they are truly victims of domestic violence, but because they don't understand how to obtain one and how to prosecute one effectively, their restraining order is denied. It sometimes takes me a few interviews with my client to pull out all of the facts and all of the instances of domestic violence. I mean, it's something nobody wants to talk about. And I think that happens so often in the courts where they can't articulate for the judge why they need this restraining order, and then it's denied. And that to me is tragic. And so just as much as if you need to defend a restraining order where the alleged perpetrator isn't a perpetrator of domestic violence, and what are the ramifications of that? What about a victim leaving the courthouse with no protection and having to go home to their perpetrator? And I think you need an attorney in both instances because, again, I've seen it time and time again, self-represented litigants not effectively conveying the information. And this is just too serious of a matter to not succeed in either way.
Thank you, Christy. Do you have anything to add to that specifically?
Yeah, I think that Christy and Colleen would both agree with me that it goes to that intangible fear. I mentioned earlier that many times the actual physical harm happened years ago, and they know that it could happen again, but it hasn't happened. It's more threatening behavior that they know is going to lead into something physical but doesn't. And that is why it is so important to have an attorney, because we are experienced at pulling the information out in a way that the court is capable of understanding. Because the court needs to understand that if the person, stands in the doorway while the other was taking a shower, that is a threat because this happened in the past.
Thank you, Gina. Colleen, what are other ramifications for the person who's got the restraining order filed against them, the perpetrator?
Well, as for the permanent restraining order, I assume is what you're referring to.
Mm-hmm.
Well, one of the things I just wanted to kind of unpack to what Gina had mentioned is custody. So there's a presumption under the family code that if you're considered the perpetrator of domestic violence, the presumption is you can't have joint legal custody of your children. And you can't have joint physical custody of your children. And so there's going to be things normally that's required that the court will issue or require you to do in addition or as a result of the permanent restraining order, such as taking DV classes or prevention of domestic violence classes, parenting classes. If there's drugs or alcohol involved, some sort of rehabilitation, passage of time, therapy sometimes if that's required, or anger management classes. A variety of things that you're going to have to do in order to satisfy the court to get rid of that presumption now that you have a permanent restraining order issued against you. So it's a very big deal, and it's something that should not be tread lightly if you're thinking of going to court by yourself for a permanent restraining order. And as Gina said, I've seen it too with people who don't have attorneys. They're like, yeah, I don't care because I'm not going to see her, whatever. And then they get this strike against them, really. And if you think about it that way, and there's such severe consequences that they're not even aware of because the courts can't explain it to them because that's giving legal advice. And if they don't have an attorney, they've never heard this before. But I've seen military members getting kicked out of the military, background shows up on your background check. So I would imagine too that if you're even looking for an apartment, it's going to show up on there as well. Anytime that they're going to do a background check, that's going to be on there too. The difference between a permanent restraining order though and a temporary restraining order, that a temporary restraining order isn't on your permanent background check yet either, but it permeates for a long time. The effects of a permanent restraining order in many aspects of someone's life. You're muted, Bishoy.
Sorry about that. So can someone be arrested if they violate the restraining order, the civil restraining order?
Mm-hmm. Can they be arrested?
Yes.
Is that your question? Yes, they can. So for the pendency or whatever the time that, so I don't think we've talked about it. A permanent restraining order, if you're sitting in the hearing, the judge is going to say, they'll ask the victim, how long do you want a permanent restraining order? I can issue it for a day or I can issue it up to 5 years. So depending on the duration of that restraining order, you violate any of the terms that are spelled out in your restraining order, you can be arrested and then you could be prosecuted as well for violating that restraining order. So now you're looking at whatever ramifications or consequences in family court, but also on the criminal side as well. And then opening up that that can of worms, that other legal situation with the criminal court. So yes, in short.
Thank you, Colleen. Christy, I want to get back to you for a second because you covered the ramifications for the victim. How does a restraining order affect spousal support orders?
Well, there is a presumption, or I'll take that back. It is a factor the courts consider in ordering spousal support, either to the recipient or the payor. If the payor is a perpetrator of domestic violence, it's a factor that may increase their support. And if you are a perpetrator of domestic violence and you want support, it might affect your ability to receive it. I also want to make one comment while Colleen was speaking, that, and it goes to support and finances. The financial ramifications of a restraining order are extreme. The batters and intervention class that Colleen was speaking of not only is a 52-week course, so that's 1 year. You have to be in class every week at a batter's intervention course for 1 year, but you also have to pay for that. So there's extreme financial consequences to if you're either the perpetrator, and like I said, if you're the victim, it is a factor the court will consider in giving you spousal support.
And what about pension plans? Are those affected by restraining orders?
They could be. If there is a criminal case and the penal code section that you violate is severe enough that it could impact your ability to receive 1/2 of the victim's pension, that is very case specific. It's not a general rule, but what I see, and I think we discussed when we were talking about this topic today, is what I see going on with the current status of the law is that the courts are expanding the notion of what we consider domestic violence. The stroke, if you will, the brush stroke is getting a lot broader in that regard. It used to be, when I started practicing 17 years ago, if you didn't have a black eye, then forget about it. But it has become way more expansive than that. We appreciate the subtleness of something like harassing, threatening. So it's not so just physical anymore. And I see it going even further than that. And you can understand the logic in something like, why should a victim of domestic violence have to give their perpetrator 1/2 of their retirement based on the length of their marriage? And that's the law. And so to deviate from that, I think is sending a message to perpetrators of domestic violence that, their actions are going to have a consequence, and they are really extreme. So.
Thank you, Christy. Colleen, do you have anything to add?
Another ramification that we haven't talked about is the fact that a restraining order, it affects your constitutional rights. So it tells you where you can and can't go, because it's usually a perimeter around the victim, their home, their car, their workplace, school, sometimes a children's school. So you have to think about that. So you have to be cognizant of where you are, and it usually specifies a distance where you're supposed to stay away from. Also, it can affect your property rights and your access to your own private property. So, like Christy, I think Christy had mentioned, you could ask for a kick-out order to the victim, to the perpetrator. Even if you own your own house, it's your house, you're on title, you could get kicked out of your house. And if the court can continue that order even at the permanent restraining order. So just thinking about it one step further, other than the finances, it's affecting your access to your own property and where you can be out in the world. So we cannot harp how severe that these permanent restraining orders can be.
Thank you, Colleen. Gina, do you have anything to add?
No, I think that we did a pretty good job outlining how serious a restraining order can be, but we also need to just be mindful of the victims. Domestic violence is real. The fear that victims feel is real, and they do need to be protected. As attorneys, we do have various tricks up our sleeves because it's very common. For instance, we're representing a victim whose husband is a firefighter or a police officer. It's very common for the victims to be worried about the other party's job because maybe they're the sole provider in the home. And if that person loses their job because they now have a restraining order. For instance, if someone's a police officer, they're not going to be able to carry a gun if a permanent restraining order is granted, ergo they're going to lose their job. So we've got a bag of tricks that we can pull out to continue to protect the victim, but safeguard the other person's job, because it's really about protection here.
And I also want to add to that, Gina, is there is a fear aspect. If the accused perpetrator is a policeman or a firefighter, that they have connections in the law enforcement. And oftentimes the victims feel like there's nothing that they can do. They feel hopeless. And again, to you guys' point, is that is not the case.
Well, it is a good old boys club with firefighters, paramedics, police officers. I've seen that many times on the street, which is why you asked the question, Bishoy, how can it be that somebody can not have a restraining order granted by the police or not have the perpetrator arrested, but we can still go into court and we can still get protection, because that cowboy attitude on the streets doesn't work in the courts. And those type of people need attorneys more than anyone, because there is that intimidation. There is that feeling that the victim is alone. And there's a feeling that they're being ganged up on and not believed.
Agreed. I do want to take the time to thank you guys for joining me again. Today's topic was very informative. You guys shared a lot of information. And I do want to remind the participants that this recording will be posted on all of our social media websites. Please continue to email us and send us any questions that you may have. If you feel that you've been wrongly accused of domestic violence or you need a domestic violence restraining order, please feel free to reach out. Phone number is 951-587-0505, or you can reach us via email at info@temeculadivorce.com, or you can even access it through our website at temeculadivorce.com. So do me a favor, if you have any questions, please send them. If you need advice or guidance, reach out to us. That's what we're here for. And we do wish everyone a healthy and safe life as much as possible amid everything that's going on with COVID right now. So please be healthy and safe, and please just focus on your health right now. That's the biggest thing. And I'm rambling. So again, I want to thank everybody for joining us, and God bless you all.
Bye.
Bye.